All right. Board of Appeal and District for the State of Florida is now in session. Honorable Dan Traver, Chief Judge, presiding. All persons having business before the board, draw near, give attention, and you will be heard. May God save the United States of America, State of Florida, and this honorable court. Please be seated.
All right, thank you, Marshall Crawford, and good morning, everyone. We are in session for oral arguments at the Sixth District Court of Appeal. Before I announce this case, let me introduce the panel and make a quick housekeeping announcement. As Marshall Crawford said, I'm Dan Traver. I'll be presiding today. Seated to my right and your left is the Honorable Petra Brownlett. Seated to my left and your right is the Honorable Roger Ganem. The housekeeping announcement is that we are streaming live via YouTube. So if you have not silenced your phone already, I would be truly grateful if you did. This case is 23-3172. It's John W. Mina, Sheriff of Orange County, Florida, versus Sean M. Hurley. Counsel, 5 minutes is the typical default that we do for rebuttal. Does that work for you, or would you like more or less? Terrific. Whenever you're ready, sir.
May it please the court. My name is Robert Hauser. I'm from the firm of Sniffen and Spellman, PA, and it is my privilege to represent the Sheriff of Orange County. And it is a pleasure to make my debut in 6th DCA. We're talking about a $20 million verdict this morning for mostly pain and suffering and non-economic damages. And with that verdict goes a 100% liability attribution against the sheriff vicariously for the acts of the deputy. In this trial, my client, the sheriff, proved that the plaintiff had operated his motorcycle knowingly, intentionally, without a working front brake. My client proved.
So maybe this gets to your cumulative error. You know, you've talked about 5 different bases for this, and you're not challenging the remittitor. You're not. I understand that you are surprised, you know, by the jury's allocation of no comparative negligence and perhaps the damages award. But in terms of what you're asking us to do in terms of legal error, you've outlined 5 issues. Which do you think has the most heft or value to it?
I'm torn between the first and the second. I mean, I think we got killed by the citation evidence because I believe that when the jury learned that my client was cited, but didn't hear anything to sort of resolve that, they made the assumption, as I would, that if they were cited, they were fined or found guilty, and the Florida judicial system has already decided this. And so that was really bad for us, and we're probably in trouble when the judge told us that we weren't going to be able to let the jury know that that citation did not result in a fine or adjudication of traffic guilt. Like, I think that's a big problem.
Counsel, I don't know if you were trial counsel below in this moment, but there's no objection to that the minute that that comes out, right? I mean, so number one, isn't there a preservation problem with regard to that? And then number two, was it just strategic and the defense team really thought, well, we'll be able, you know, when we get up there, we'll be able to bring all of this other evidence out about the acquittal?
Well, there's no question that it's a preservation problem initially, because if I had been there, I might have jumped up and down and screamed mistrial, and the trial might have ended right there. But that's not what happened, right? The defense team said, okay, this has come in. We don't want to make a big deal about it in front of the jury, but we can always counter that and get back to neutral by letting them know that that citation, which is terrible evidence, is mitigated by the fact that that did not result in a adjudication of guilt. So the error, the court's right on the money here. The fact that the citation came in, nobody objected to that. But it's not like they were Boy Scouts and said, oh my goodness, Your Honor, we didn't mean for that to come in and let's strike that. So they
Well,
will.
the way to do that, and I get, as a former trial lawyer and trial judge, the jumping up and down thing, there's a way to do it. And isn't the way to do it at that point, hey, judge, can we approach? And just basically say, look, counsel here didn't elicit this particular information, but it happened. I got to move for mistrial. I got to object and move for mistrial. At that particular point, do you think that the trial court would have been in its discretion to grant it?
I don't know. And it doesn't bother me.
Because I mean, if the trial court was not in its discretion to grant it at that point, I don't understand your argument.
So I'm on board with the hypothetical. If I had been there, I might have sort of mumbled for a mistrial and had that in the back pocket for the judge to reserve in case the trial is a bad result. I could see that happening, but that's not our case. Our case is neither side objects, it comes in. And so now the question is, how do we address it? They've opened the door. That's our argument. That was the argument that this judge actually had before her. They opened the door, and all we want to let the jury know is that it didn't result in an adjudication of guilt, because that's the
So
assumption.
your argument is correct that not being able to do that, then you could not cure the prejudice that the defense suffered in that moment.
Correct.
So what do you do about the fact that there was other evidence in the case that it was clearly, and I think that Officer Rizzi himself mentioned that indeed Mr. Hurley had the right of way. And so if we have all of these concessions in there, aren't you nonetheless prejudiced by these statements? I mean, we have this, the officer saying the other guy, Mr. Hurley, had the right of way. And so wouldn't you have already been sufficiently prejudiced if that was the true concern?
Well, we already have the bad facts that my client had a stop sign, right? There's no question about that. My client had the stop sign, but that is not the same as the long arm of the law adjudicating him guilty of running a stop sign and failing to yield, which is my issue. So now the second part of your question, it's like really my second half of my answer to your question, is the directed verdict on causation.
Mr. Hauser, before we
Sure.
move on to that, I wanted to follow up on the citation. It seems like the fact of citation is bad, and the fact of acquittal is also bad for different reasons. And it strikes me as what you're asking us to do is to say it was an abuse of discretion for the trial court not to basically say that two wrongs make a right. On the one hand, the fact of citation could be misleading because it's simply a hearsay, issue. It hasn't been adjudicated. But on the other hand, if the fact of acquittal comes in, well, then we have the problem of, well, what, different burden of proof in that proceeding as compared to the civil proceeding. Why was there an acquittal? Was it on the evidence? Did the officer not show up to court? And it seems like you're just creating an additional problem for the jury instead of simply curing the first wrong with a curative instruction, which did occur here. So why isn't it better just to correct the one wrong than to allow a second wrong by bringing in the fact of acquittal? Seems like that makes the jury's job harder and less clear than the way that the court handled it here.
Well, I disagree a little bit. Like their argument is, oh my goodness, evidence of an acquittal is not admissible. Of course it isn't. But they've opened the door, so it has to come in. And yes, two wrongs do make more of a right than what we have here, where the jury is actively misled, right? This jury is basically defrauded into thinking a law enforcement officer cited the deputy, he is therefore guilty, because they never heard otherwise. And by the way, the plaintiff theoretically could have been cited because he was violating the law too, but the jury never heard that. So yes, in this particular cases, two wrongs do make.
Do you
a right.
acknowledge, though, my colleague's statement that this is a discretionary decision on the part of the trial court?
Within reason, except there's all this case law.
So do you also acknowledge that there's case law out there which says that it's an abuse of discretion for a trial court to open a door too big, too wide?
I agree, but I think
Okay.
the court has.
So if you've got if it's a discretionary decision, whether the door's been open, and it's a discretionary decision on how far to open the door, just address Judge Ganem's concerns that if you do that, you're effectively risking introducing a whole bunch of evidence and having a trial within a trial. Well, here's what precisely was introduced at the traffic citation hearing. Well, let's just read the transcript. And all of a sudden, you're not trying a personal injury case. You've imported an entire traffic citation with a different standard of proof and different actors with different motivations in it.
So I'm with you and I don't disagree with any of these big points, but I think the court has to, know it when you see it. Look what I have here. I have a jury that's going back to the jury room thinking that that citation unquestionably must have resulted in a adjudication of guilt by persons in black robes. Otherwise, why didn't I hear about it?
What do you
So
make of
that's-
the jury instruction that that trial counsel settled on?
It's okay and it's correct, but there's almost nothing that we could
Would you have made it a little bit stronger?
in hindsight, probably yes, but there's nothing that could be
Was
done.
there anything suggesting that the trial court would not have signed off on a stronger instruction? I mean, she offered a curative, which your client rejected in the moment, in lieu of a jury instruction, and then seemed to be very wide, open as to what the jury instruction would be. Did she take what your client proposed?
Yes, we didn't object to the instruction, and I'm not here to complain about the instruction. What I'm here to complain about is the jury going back with the misimpression that the long arm of the law adjudicated my client's deputy guilty, which is the obvious inference, and nothing to counter that. Now, I don't like the idea of a trial within a trial. The only thing the jury needed to know is that that citation did not result in an adjudication of guilt, and they still need to decide who's right or wrong on the question of negligence and not be influenced by what happened in traffic court. But that's all. And anything else, I agree, is a mess. And I wouldn't suggest it. Now,
Do you have any case, counsel, where there's an analogous situation to ours with the witness just sort of offering this testimony instead of it coming out due to the specific questioning of counsel? I couldn't find that in the cases cited, and it seems to me that that this just came out, right? It wasn't precipitated by counsel asking the question. So what's your response to that? I mean, where's the case law saying that they have opened the door? Plaintiff's counsel very quickly told Judge Schreiber, I didn't ask that question, Judge.
I don't think there's any case law that says you have to intentionally open the door.
No, that's not my question. Just the fact that plaintiff's counsel did not ask the question in a way that required such a response.
I agree, they did not, but
But that's
nevertheless,
nonetheless opening the door.
it's not knowing they opened the door, but they did. And the evidence is out there and something needs to be done about it. And so the best case law that we did provide to the court is a mountain of cases that all demonstrate the terrible effect that having that citation evidence in the back of the mind of the jury is. And that's really the best we can do, I'm afraid. So I'm going to ask the court to make the leap that if all that evidence is terribly prejudicial under the case law, the jury has that, they retire to the jury room believing that my client has been adjudicated guilty of the citation, then they would have punted. Now, I really need to get to the directed verdict because it's probably just as bad. I mean, this judge took away from the jury the issue of causation, which really is the whole case, right? Here I am arguing that this plaintiff caused the accident by denying himself the ability to brake efficiently. Like there's no one in this courtroom who would get in a vehicle that didn't have an operative front brake. There's no one who would let a family member get in a vehicle that didn't have an operative front brake, especially a motorcycle type vehicle where there's no metal around you to protect you in a collision. So we proved that the front brake was more important than the rear brake and braking. We proved that the lack of front brakes contributed to the accident. But when we get to directed verdict, we have this dialogue. It's in the 870s of the transcript. So it starts out as them saying, we want a directed verdict that all the damages caused were caused by the accident. Now that would have been incorrect to grant because we know that the plaintiff had a pre-existing injury, but they got it. But this dialogue then morphed into something far more insidious. The trial judge walked out of this dialogue thinking that any negligence by the deputy is a legal cause of the accident. So any negligence. So even if my client.
Yeah, I don't know that that appropriately characterizes how the trial court came out of it, because there was a discussion about Lancheros and a lengthy distinguishment of it. So I don't necessarily know, and I'm sure you didn't mean it this way, but I'm sure that this wasn't a situation where the trial judge just ignorantly stumbled in with an inaccurate impression. I mean, there was a complete discussion about the case that you insist most benefits you.
I think the judge's language speaks for itself, and I'd invite you to look at page 882 of the transcript. There is no chance that the judge walked out of this ruling other than as I am characterizing. Now, how we got there, I may be misinterpreting what the lawyers are arguing to her, but I know that the judge walked out of that dialogue ruling that any negligence by Deputy Arizi is a legal cause of the accident. And that ended up in the verdict form and the jury instructions. And what really hurt us is that, and I don't blame them for doing this as trial lawyers, they went out of their way to show the jury that Judge Schreiber had taken away their burden of proof on causation. Any negligence by the deputy meant damages. So our whole argument that there's comparative fault here, that the plaintiff took away his own ability to brake is the reason for the accident. And if not the reason, a huge contributing reason. And instead, the judge put her thumb on the scale and said, defense, you have to prove causation, but plaintiff, you do not. And Your Honor, I do invite you to take a look at the judge's exact words on page 882, and then how plaintiff's counsel relied on that language to show the jury that there was an asymmetry in the instructions, whereas we had to prove causation, that braking problem or the fact that the plaintiff was speeding or that he was probably wearing headphones. We have to prove causation for that, but they don't have to prove causation. If Deputy Arizi was negligent, same guy who was cited for failing to yield, if he's negligent 1%, that's the legal cause of the accident. So during the break, I'm gonna get the actual transcript and I will read it on rebuttal so that we have no misunderstanding.
You can use your rebuttal time however you want, but
Gotcha.
you have told us the transcript page twice. So use it however you'd like.
Maybe I can find it too.
Okay,
All right, I'm gonna reserve the rest of my time. Thank you, sir.
counsel.
Good morning to the court. May it please the court, my name is Brian Lee. I'm representing Sean Hurley in this case. Just want to start with both points that appellant's counsel has brought up regarding the citation as well as the causation argument. There's
It's okay with you guys. Can we focus on the second?
sure, whatever the court
Yeah,
would.
second first, please.
Yes, so the causation argument, Your Honor, if you look at the transcript, there was the directed verdict motion that was made by Mr. McLean at the trial very clearly talks about a legal cause. It does not say that we're wanting you, Your Honor, to say that every single bit of damages is caused by this. It's saying we are moving on a very distinct legal causation argument that there is no evidence to the contrary that injuries were caused by this crash. Now, what that means is that the second part of that question as to number one would then not be decided by the jury. And that's what the trial court did. The trial court essentially still had the question about whether there was negligence on the part of the sheriff's deputy. And that was, and certainly if the jury would have said no to that, that's it. So there was nothing about the conversation that occurred regarding the legal causation motion that I believe, I've looked the record many times, that the trial court misinterpreted. And I think, Judge Traver, you talked about it specifically. This court was given the case of Lancheros and looked at it and at length distinguished it and talked about it. I also talked about the case, I think, of Wall versus Granger, the Supreme Court case. And I'm looking at 882. I'm not sure if that was the page that counsel talked about, but that's where the trial court distinguished Lancheros and very succinctly and said that, look, in Lancheros, we had a situation where there was evidence that kind of the premise, and I'm speaking to the choir here, but the premise of Lancheros was that there was one injury, there's back injury. And there was the expert testimony was undisputed that the back injury was caused by the crash. However, there was testimony regarding a prior chiropractic treatment of that back injury that was years prior to it. And then there was also evidence that Mr. Berg didn't see I think he was either any doctor really.
Anybody
for about, I think it was 12 days, if I'm not
18.
mistaken. 18, you're right, correct, Judge, obviously. And so that was the evidence that this court said, look, you know, the jury could have disregarded the expert testimony and found that because that evidence was in the record as
That this accident didn't hurt this guy. That's basically it, that this is a soft tissue injury, that this accident did not hurt this guy.
correct.
I struggle with the argument from your colleague that there isn't evidence that this accident hurt this guy. I mean, his bones are sticking out of his legs.
True, Judge.
It's an open book pelvis fracture, you know, like, so in that sense, I wonder what evidence there is in the record. And I see where, and later on, the trial court said, I wish you would have called my attention to that decade-old knee injury that apparently wasn't bothering him at the time.
Sure.
I don't necessarily know that we can read Lancheros as being equivalent to this particular situation.
I don't either, Judge. And the reason why is I think what you alluded to right from the beginning is that in Lancheros, and Judge Traver, I read your opinion again. I believe that soft tissue was a very big part of that. And so we're not talking about just
I mean, your client in that case, the defense's argument was he was not hurt by this accident.
That's correct.
I don't know how you can say in this case that this particular plaintiff was not hurt by this accident.
And I agree, Your Honor. And we know that they weren't doing that because I noted right at the beginning of the trial, an opening statement, defense counsel came up to in front of the jury and said, we're not saying that he wasn't injured, meaning our client. So from the very beginning, I will say in fairness, there was a statement of the case which said you were contesting liability, causation, they were contesting everything. But the first thing out of defense counsel's mouth was that we know he was injured in this crash. That continuum went throughout the entire trial. There was zero evidence in this case that the fractures didn't happen and that all the things that you are aware of, Judge, happened in this case. There was evidence regarding the left knee that was brought up. And there certainly was there, but there was absolutely no evidence that a fracture and the toes and all the way up through the legs, tibia fractures didn't happen in this crash. They didn't argue that. And so when the court at page 882 of the transcript is talking about that very thing gets brought up. The court said that this is distinguishable from Lancheros because we have a case here where there are fractures that happen. There is no evidence that that fracture happened other than this crash, period. And throughout the entire arguments that were made, there is not one time that defense counsel even argues that, well, Judge, no, there really was this other thing that happened. What they're saying is that, no, we agree with all that. We agree that the fractures happened in this crash, all that happened. We're just saying that the left knee, we have some evidence regarding the left knee. And what the trial court didn't do, was the trial court didn't direct the jury that, well, if you find that the deputy was negligent, then that means you have to give all the damages that plaintiff is seeking. Trial judge didn't do that. The trial judge still allowed, and you can see from the record, that they argued about what the extent of the damages should be. That was proper in accordance with what Lancheros said, in accordance with what all the case law, even before and after, says that as long as you give the jury the ability to determine the extent of the damages, that a legal causation directed verdict is proper. And I don't think there was a sort of an intimation, and maybe I'm wrong about this, within the brief that, like, you know, and this court did say that, you know, look, these should be rarely granted. That was something you put in the decision, Judge Traver. And there's a sort of an intimation that, well, that really means that they should be never granted. And I don't think that's what this court is saying. I don't think that's what you said, Judge Traver and Lancheros. I don't think this court would be saying that now, because there are some situations like this very case where a jury cannot be allowed to make or to give a verdict that is totally against every single bit of evidence in the case, and frankly, against common sense. And this is that case.
Mr. Lee, I want to ask about this asymmetrical jury instruction. Given that the directed verdict says the collision caused the injury. The instruction regarding the deputy was that if he's negligent, well, that necessarily caused the collision, but on the defendant's side, I'm sorry, on the plaintiff's side, the instruction was, well, if you find negligence here, the jury still has to find that negligence was a cause of the collision. What is different about the negligence alleged on the part of the deputy as compared to the negligence alleged on the part of the plaintiff that would allow that asymmetry in the instruction?
Sure, and I looked at that issue because I figured that was something, a question that would come up. I think where I begin, maybe even end, is that the plaintiff moved for a directed verdict on legal causation. It was granted. Defendant didn't. There's nothing in the record where the defendant either before or after says, well, judge, if you're going to say that the crash caused the injury or damage or loss, well, then that should also be the same thing for the plaintiff. That didn't happen. They didn't make that link. They didn't make a motion at all about that. Now, I don't know whether the court would have granted that motion. Probably would have, based upon what her reasoning was.
Would your firm have opposed that?
I can't see how we would have been able to, judge, because we can't on one hand say that, well, the accident, the crash itself caused a loss, injury, or damage to Mr. Hurley on one instance, but then say, but it's different when it's thing. Now, the argument that you did see that was talking about the negligence, whether there was actually negligence on the part of Mr. Hurley, whether, not wearing wearing earbuds, not having a front brake, was that, was there negligence by Mr. Hurley? That certainly was something that the jury looked at too. But to answer your question, I don't think we would have, I think there would have been in a different situation. Let's put it that way. If defense counsel at the trial would have said, well, judge, what's good for the goose is good for the gander, I think we should have a directed verdict too on that. And we should just be giving the jury questions about who was negligent. And that's it. And the judge said, no, I think that's different. And so I'm going to deny your motion. I think we would be on a different standpoint then we would have to argue that, but that didn't happen. And so the trial judge, of course, couldn't grant motions on its own, couldn't make a motion on its own. And so, and I'll note that when the court did go through pretty painstakingly the verdict form, the jury instructions, there was never anything brought up about that other than what had already been argued, which was specifically as to this whole, you can't grant a causation directed verdict because we had this left knee stuff. That was the only argument that was made at that point. So I think that this court can't now, even if it wanted to, go back and say, well, the judge should have done that because the judge was never even asked to do it. I hope that answered your question.
In part, I guess I'm just wondering if is it because the alleged negligence on the part of the plaintiff, the earbuds, the speeding, the lack of a front brake. When I look at those things, they may or may not have caused this impact. I mean, the reason for the impact was the deputy's vehicle was there, and you have the essentially, I don't, it might have been moving slowly, but basically this sort of immovable object and this, this motorcycle coming at it at whatever speed. So I'm wondering, is it because if the deputy was negligent, the only thing that negligence was responsible for was like putting him there, whereas the alleged negligence on the part of the plaintiff may or may not have caused the collision, and we heard, I guess there was evidence both ways.
Sure.
Did the lack of a front brake cause him to hit the deputy or not?
Yeah, maybe I misheard your question. I'm hearing what you're talking about. Yes. I mean, there was that, there was still that issue because we know that, like you said, the deputy coming out was the hit. The fact that there was still a question as to whether braking would have done anything, having front brakes would have done anything, whether the earbuds did anything to stop anything, right? So, I mean, there
weren't even earbuds there, right?
And there weren't even earbuds there. right? It was just sort of a supposition that was happening. So there is a situation that even, look, we're sort of hypothetically saying that, yes, I could see that argument being made by plaintiff's counsel that, we know that pulling out there, that hit happened, because that was what the negligence was of the deputy, not something he did prior to that, or not something irrelated to his vehicle actually going out. The negligence of the plaintiff, Mr. Hurley, that was put in front of the court was not that he saw it and ran right into it or something. It was all these other things that they thought were negligent because he wasn't able to maybe perceive it in time or was able to stop in time. So yes, there still would have been that argument that would have happened, but I guess what I'm trying to say is that, going back to what I said before, is I don't know whether the judge would have made the same decision. But I can certainly tell you that if they would have moved for directed verdict, then the judge wouldn't have, and would have denied it, I would be arguing the same thing that you're mentioning, Judge Ganem.
I take you to agree that under the directed verdict as it was entered, that if the jury had said the deputy was 0% negligent, in other words, just wasn't negligent for being there, then that would have been, there's nothing about the judge's directed verdict ruling which would have prohibited that outcome, right?
Correct. Yeah, and that was the first question on the jury form. Yeah, absolutely. And I think the court sees throughout the trial that was the that was the issue. That now I will say, going to that specific question, Judge, that defense counsel, and I don't think defense counsel is going to disagree with this because it's in the record. The defense counsel in closing statement came up and told the jury to put negligence on the deputy. The closing statement of defense counsel said, jury, you should start at 50-50. This is very different than what they had said in opening statement. You should start at 50-50, and we think, defense thinks, you should put 87% on Mr. Hurley and 13% on the deputy. And so just from the way that this case was positioned to the jury, there's no surprise that the jury checked yes, because defense counsel was telling them to. So now, did they check no to the second question? Yes. They believe the evidence. They believe that Mr. Hurley didn't do anything wrong. And that was their decision. But this argument that's sort of laced in the brief that talks about all these things that happen and that caused the jury to check yes to the first question, I think is belied by the fact that their own counsel told them to, as part of his argument. So with that, there's nothing that we feel requires a reversal in this case, and we would ask the court to affirm, unless there's any more questions I can answer.
Thank you.
Thank you.
Brief rebuttal. So I found what I was looking for on page 82, 882, 883, and again on 886 of the transcript. Those are the PDF pages. And in each case, the judge ruled that if there was negligence by Deputy Arisi, it was the legal cause of damages. And that is the disputed issue in the case.
But isn't it true that if based on the evidence that was presented, that if the deputy was negligent at all, it was simply because his vehicle was there in that lane of travel that Mr. Hurley was in. Whereas the various negligence alleged as to the plaintiff were a whole bunch of things where, if the deputy was negligent for having his car there, clearly that was a cause of the collision. I mean, he was there. That's the only negligence alleged for him. Whereas the earbuds, the brakes, the speeding, all of those things may or may not have contributed to the accident. And so it's appropriate to ask the jury, did they or didn't they? the deputy was negligent, it's because his car was there. It wasn't, there was no other kind of negligence. Like he didn't have a speeding issue or a brakes issue or anything else. That the jury would have to decide, well, did that contribute? If he negligently put his vehicle in that lane, well, clearly that contributed or was a cause of the collision because, that's the only negligence alleged for him.
No, Your Honor. What if the plaintiff had brakes that work?
Yeah,
But if-
but wasn't the testimony that the plaintiff he has the right of way, first of all, undisputed. He goes past am I correct? He goes past the officer comes out, clips him on the back. Mr. Hurley testifies, well, if he had hit me in the middle, I'd be dead, right? So he's trying to go kind of around him, right? Is that correct?
What's correct is that the plaintiff sped up because he knew he couldn't stop. And he attempted this incredibly dangerous move where he tried to go in front of the car. Your Honor is correct. He got clipped and then he stayed upright, but he must have been out of control because he went several hundred more feet before finally losing his mount on the motorcycle.
So why would brakes then? Because your comment to Judge Ganem, I thought was, well, if his brakes had worked. You're presuming that he just would have braked before the officer pulled out, even if
Yes.
he has the right of way?
Yes, he could have stopped. He could have avoided this accident.
We
That's
still had the rear brakes, right? And those are stronger supposedly?
No, the evidence is the front brakes are the ones that matter. They're the stronger brakes. So he had to do this contrivance where he tried to use the transmission of his motorbike to slow down in conjunction with the rear brake. So our whole point is this plaintiff intentionally increased the kinetic energy of this collision because he knew he could not stop. Most people, and this is a jury question, most people could have just stopped and avoided the collision, whether Deputy Arizi was in the wrong or in the right. So the whole problem here is that it is unclear, and it was a jury question, and this court hit the nail right on the head. It is unclear, and it was a jury question, that even if Deputy Arizi negligently operated his vehicle, that it would have resulted in an accident. Because we've got a plaintiff who should have been able to stop. And if he wasn't able to stop, he should be able to decrease the kinetic energy of the collision. And it's also unclear on our side. Even if Sean Hurley was negligent, could he have avoided causation? We don't know. Those were jury questions. So my problem with the asymmetry that this court has acknowledged is Judge Schreiber is telling the jury that any negligence by Deputy Arizi is a legal cause of the accident. And she's not telling the jury that any negligence by the plaintiff is a legal cause, and neither is a legal
But
cause.
did you ask her to make that? Because I think Mr. Lee's point was, well, the defense never asked for her to give that instruction to the jury.
And that would have been a completely frivolous request, and no defense attorney with a straight face would have made that request. And his concession, I find to be remarkable. There's no way that we would have asked for that. There's no way we should have got it. And that's the same reason why they shouldn't have got it. I mean, Lancheros is kind of a red herring here because it's worse than Lancheros. We already knew that this guy had a pre-existing injury. And so the accident is not the cause of all his injuries. It's only the cause of some of them. And it's up to the jury to figure out which ones. But when Judge Schreiber
Was there any evidence that Mr. Hurley was driving down that street before the accident with a dislocated knee?
only his testimony that I quoted that he had a pre-existing knee problem.
Not my question. Was there any testimony adduced at trial that Mr. Hurley, before the accident, was driving down that street on his motorcycle with a dislocated knee? Was his knee dislocated before the?
That does
before the
not
accident?
ring a bell for me, so I'm gonna guess no.
Okay.
I have to rely strictly on what's in the record about his pre-existing, it's almost a young adult knee injury, so.
Right.
Based on the errors that we've identified, in conclusion, we urge the court to remand for a new trial where the citation evidence is on a fair playing field. Either it doesn't come in at all, or both sides get to show the jury that it was not pre-existingly resolved. And there should be no directed verdict on causation for either side because it stacks the verdict. And here it stacked it
You
100%.
sounded like you were wrapping up, but it doesn't sound like you are anymore.
That really is. That really is.
All right. Thank you very much, both of
I
you, for your
appreciate the
presentation.
kind attention of the panel.
Yeah, of course. We're going to take a minutes long recess because we just need to switch the panels. There's another case that is going to go right after, and the attorneys who are there for that are welcome to come up and get set up. Thank you. We'll be in temporary recess.
All right. Please be seated.
Good morning. Welcome back to a morning session for the Sixth District Court of Appeal. We have one case remaining this morning. It's Morabel versus the State of Florida. My name is Judge Nardella. I'm joined today by Judge Ganem and Judge Mize. The appellant has 20 minutes, as does the appellee. We typically reserve 5 minutes for rebuttal, but if you would like a different increment of time, please let us know. Counsel for 5, okay. Your argument today will be broadcast. And with that, whenever you're ready, you may begin.
And please the court. Counsel. Spencer Cordell on behalf of Vladimir Morabel. We are asking the court to send this back for resentencing. The plea is going to stand. But at his sentencing hearing, he was not able to fully present all of the mitigation evidence that he wished to present prior to the court issuing sentence. I'd like to point out to the court today that the trial court initially at sentencing, I think, got kind of caught up in the fact that his substantial assistance, which we were presenting for mitigation, once it was determined that the court couldn't go below the mandatory minimum sentence because the state hadn't filed their motion for substantial assistance, that the court said, I don't need to consider substantial assistance. Forgetting the fact that there were two purposes for it. One, if there was a substantial assistance motion, then the court could have gone below the mandatory minimum. But even without that motion, it was still evidence in mitigation. The substantial assistance, the 5 people that we proffered that he had given information to law enforcement for, that resulted in arrests, that resulted in prosecutions, was something that needs to be considered when the court is determining the appropriate sentence. And it's also important to note, the court didn't restrict itself to the mandatory minimum. The court actually went above the mandatory minimum, sentenced him to 30 years on the trafficking counts. So that mitigation evidence certainly would have been relevant as to whether or not he needed to be sentenced to more than the mandatory minimum.
Counsel, can you speak to us about whether or not the trial judge was fairly appraised of the argument you're making today when it comes to putting your counsel on the stand for that evidence?
He was fully appraised that we intended to put that evidence on. And I was the trial counsel on this one. He asked me a specific question. Is there any way I can go below the mandatory minimum? Is there any way I can consider this when the state hasn't filed the motion? And my answer would still be no. You can't go below the mandatory minimum. And after that point, the judge didn't allow me any additional explanation. He actually said, I can't consider it, or something. It is something I cannot consider unless and that was on page 47 of the sentencing transcript. And then a page later, he said, it's something I can't even consider unless I have a movement from the state. And we said, we still think it's relevant, Judge. And that's the question on whether or not something can and must be heard by a sentencing court, is whether or not it's relevant. All right. The issue was, I did want to talk about preservation, as that was brought up in our request for additional briefing on the matter. The issue was clearly preserved. There was no objection because it was something that we were trying to introduce. I think we laid a pretty clear record of what we were trying to do. We got a clear ruling from the judge that it was not admissible. There was nothing for us to object to. There's no talismanic or magic words to preserve a record. I don't think we would have had to proffer that evidence because we'd gotten a clear, we had indicated specifically to the court what we wanted to introduce. We said, we've got 5 names of people that were arrested based on his information that we want to present to the court. And he clearly ruled that we weren't able to present it, but we did proffer it. In an abundance of caution, we said, these are the things that we would have said to the court. And
he's entitled to be fully heard. And I think the case that's really on point on this is the Hodierna case that I cited in my brief. That's the one where the individual had written out his statement. And the court cut him off in the middle of his statement and said, I've heard enough. He took the statement, put it in evidence, but didn't review the entirety of the statement. And he went ahead and ruled right then. And that's really akin to what we have in this case, that a defendant has to be able to fully present their argument, their statement, their evidence prior to sentencing.
But I wanted to ask, at some point during the hearing, as I read the transcript, it became clear that the judge was focused on this this testimony from your client as being relevant to the issue of substantial assistance for the purpose of a potential downward departure. At some point, did you need to tell the judge it's also relevant for mitigation in general, wholly, separate from the possibility of a substantial assistance downward departure? I understand you're saying it was relevant for that point. But did you need to tell the judge that specifically in order to preserve this argument here?
I don't believe so, because we made it clear what we were trying to do and made the specific point that the defendant is allowed to be entirely heard on the matter. And to be clear, the judge had ruled on it. And I guess I should point out, I think the judge got a little put out with the defendant because, and it's not clear in the transcript, it's not overt. When he says, I'm going to stop you right there. We're not going to do that. We're not going to put the prosecutor on the spot. So the judge got kind of caught up in that, and the defendant kept trying to talk, and the defendant's like, no, I'll give you one last word. And then he shut him down again. There wasn't an opportunity, again, with something that we're trying to introduce. I don't get to say I object. The judge, without objection, sua sponte, said, I'm not hearing any more of this. And I said, but we want to present it. That's preserving the record. This is what we want to preserve. The judge didn't entertain any evidence except on the issue, or any argument except on the issue of whether or not it was possible to go
So you
below the
think if the
mandatory.
judge says, I think I'm gonna stop you because I don't think it's relevant to A. And you think it's relevant to B, you don't have to tell the judge, it's relevant to B, can we keep going?
I think I have to say, I still want to present this because we're entitled to. I don't know if I said the magic word mitigation, but I wasn't given an opportunity. Like I said,
You weren't given an opportunity to say, Judge, may I be heard on this? I understand you don't think it's relevant to A, but it's relevant to B. You didn't have that opportunity? Did the judge say you as an attorney couldn't say that?
no, the judge didn't say, no, Mr. Cordell, I'm not going to hear that. I said, Judge, we believe he is entitled to be heard in full. These issues, his substantial assistance.
That's what I'm saying, the legal argument.
Right.
The legal argument that it was relevant to mitigation. I think he's saying you didn't say, right?
Right.
Okay.
And part of the challenge there is that it wasn't an objection. There wasn't a relevance objection that I had an opportunity to explain myself.
But it was a ruling in which you had the opportunity to be heard, right? The judge says, I'm excluding that because, or I'm going to cut you off because it's not relevant to A, right?
Yes.
I don't think you're disputing. You could have told the judge, it's relevant to B. I don't see anything in the transcript where you tried to do that. I said no.
I don't recall specifically trying to do that, but
Correct. That's my point.
Yeah,
You did not try. You made no attempt to do that, correct?
I did not specifically try to make that argument. I made clear what issue that we were trying to present to the court.
Correct. You made clear the evidence you wanted in. You did not make any attempt to give him the legal argument for why that evidence should come in.
No, and I would say I was not given the opportunity. I mean, theoretically,
Hold on. Why were you not given the opportunity?
because the court was very clear that we were moving on from the issue.
Did you make any requests to say, Judge, can I be heard? Or Judge, I need to tell you it's relevant to B. Is there anywhere in the transcript where you say make any attempt to be heard on it that the judge denied or said, no, I'm done. I'm not going to listen to that.
I specifically proffered what I wanted to introduce.
Counsel, hold on. So I'm asking about one thing, and I think you know that, and I think you just don't want to answer the question. And so you keep redirecting to something else, all right? So I'm asking you about the legal argument, and you're redirecting to, well, I told about the substance of what I wanted to put in. Those are two different things. So when I ask you about one, I'm going to ask you to answer that one and not try to shift to the other. Okay? The legal argument. Is there anywhere in there you made any attempt to make the argument? And if not, is there any indication that the judge didn't allow you to?
I did not attempt to make that legal argument. There's no specific indication, though, as I was trying to say, I did specifically proffer what I wanted to introduce, and he shut it down pretty quickly.
Okay. Did he shut down any attempt for you to make your legal argument as to why you should be able to put it in?
Not specifically.
Generally? I mean,
It-
say
it-
not that- did he, it's a yes or no question, counsel. If there is, I want a transcript cite. Is there a place where he denied you the ability to make your legal argument? If there is, give me a page number.
He made it clear that he was not hearing any more about it. I don't, there's not a specific site because I didn't say, Judge, it's relevant for this other reason. I said, we're entitled to be able to put this in.
Counsel, I want to move the page a little bit.
Okay.
Since we taken supplemental briefing in this case, the First District Court of Appeal, as counsel for the state has supplemented the record with, has issued Emerson versus State. I take it you have some criticism of that opinion, and if so, I'd like to hear it.
I don't think it accurately applies Jackson. I think that the Florida Supreme Court's in Jackson was pretty clear about if there's an error that happens after the plea and prior to sentencing, that there still has to be a method for appealing that. I think the dissent in Emerson made a really good point about the need for the integrity of the system, and there needs to be a method for appealing these kind of things. So I would argue that Jackson is controlling, and where Jackson says if there's an error in the process, and I would concede this is an error in the process, it's not an illegal sentence, that it should be appealable.
What is your take on the First DCA's position that you'd have a remedy under 3850?
I think that's contrary to Jackson. I think they might have maybe, I don't want to say maybe misread Jackson, but I think Jackson was pretty clear that since it's not an error, it's not appropriate for a post-conviction motion, but it is appropriate for appeal. I think that like I said, I mean, I don't know if it's called a conflict with Jackson, but I think Jackson was pretty clear about those things. So I was kind of, as you said, in disagreement with Emerson.
Counsel, the majority in Emerson decides that an error, a post plea error in the sentencing process is not appealable whether preserved or not. Judge Tannenbaum disagrees and concludes that it is appealable if preserved, but he does agree to the extent that he doesn't believe the fundamental error review is available. What about that? Do you agree with Judge Tannenbaum, at least, that it has to be preserved to be appealable? Or do you believe fundamental error review is available for a sentencing process error post plea?
I believe that fundamental error should be reviewable post plea. And the other cases since before and since Jackson have always allowed this type of issue to be reviewable. All the ones that I've cited were all direct appellate reviews of this kind of situation, and it's not clear on most of them what the preservation was or whatever. They certainly seem to think that.
Counsel, with that
it is.
belief, how do you square State versus Dortch?
Which one's Dortch?
Dortch had to deal with competency questions and the requirement that they be preserved in the rule.
Dortch is a very specific fact pattern. They said, yes, you have to be competent. And that's the one that said, but there's no harm here because there had been an order that there had been an opinion that he had been found competent from a doctor, but it hadn't been addressed to the court. And so I think Dortch is very specific to that really unique fact pattern of him.
But Dortch found that there's no constitutional right to a fundamental error review. All right, so you've got a constitution providing, at least under the dissents view in Emerson, the Constitution provides you with certain appellate rights. And one of those is the right to the review of a preserved error. You got George saying, you don't have the right to you don't have a constitutional right to appeal a fundamental error. And so then you have 924.051 saying you don't get to appeal an unpreserved error, right? So take me through how you get to the process of you still get to appeal you still get to appeal a non-fundamental error, or you still get a fundamental error review there.
I believe that except in the circumstances under Dorch, that a fundamental error is still appealable under Jackson.
So you've got George saying you don't have a constitutional right
Yeah,
to appeal a fundamental error. And then you've got a statute saying that when you plead guilty, right, you cannot appeal anything if not preserved, including fundamental errors. So tell me how you get there.
I get there because the other the statute that, and I hadn't prepared that specific issue. I did cite it in my supplemental brief that the statute that allows appeals, like subsection, I think it's E, specifically says others allowed by law. And as the dissent in Emerson says, constitutional issues are still allowed by law. I think,
But that's with the dissent. So you're right. So that's a rule. That's 9.140, 2AC2 or something. Right?
Yeah.
And he said otherwise provided by law refers to, or at least encompasses, the Constitution. And the Constitution gives you a right to review of preserved errors. But then it said it does not give you a right to review of unpreserved errors. Right. So that dissent in Emerson doesn't help you on the fundamental error question because it specifically said.
oh, I didn't remember that part of it. And then obviously only just it just came out recently.
Okay.
It's
a tough question.
Yeah,
You've got two really brilliant people in the first DCA disagreeing on it, in my mind. So
yeah, and
it's
you've
tough.
got, and I was, I don't know, my takeaway from that was the dissent saying, otherwise you've got a hole in the system where you can, like, things that happen, you're waiving your right to appeal things beforehand and not afterhand, but it's got to be preserved. But I believe our specific introduction of what we wanted to introduce preserves the issue. So I do think it's a preserved issue.
Okay, but we're kind of asking you if it's not.
I know, and I think under the Constitution, it still has to be, and I think that's the progeny out of Jackson, though I do disagree with the thinking in Emerson.
Okay, but do you acknowledge that the Supreme Court disagreed with you in Dorch and that we're bound by that? I mean, Dorch was a 4-3 decision. I'm not saying your position is crazy, but it does seem to be completely and utterly foreclosed by binding authority. We can't adopt.
I'm not going to.
We can't adopt Supreme Court.
That's problematic, and I don't remember the specific language of Dorch enough to answer that any better than I've tried to.
Counsel, you're into your rebuttal time if you want to continue.
If I can save some, thank you.
Counsel for appellee, whenever you're ready.
Good morning. May it please the court. My name is Christopher Mannon. I'm here on behalf of the appellee, the state of Florida. And I'll go ahead and start by addressing appellant's argument that his client was unable to fully present his testimony at his sentencing hearing. And in response to that, I have to say that the defendant was allowed to speak at length at his sentencing hearing at the point.
Counsel, we're all familiar with the transcript. Could you address the preservation issue that was raised?
Correct. So appellant's argument is that by indicating that he had more to say at his sentencing hearing, that he preserved this issue. However, to Judge Mize's point earlier, there was no legal grounds stated for this type of objection, nor.
Counsel, so where that language comes from is, 9104, which says to make an objection, you got to state the specific legal grounds. Is there a similar rule or authority that you have to state the specific legal grounds when you're trying to introduce evidence?
Not that I'm aware of, Your Honor. Okay. And because there was also no legal grounds stated.
Typically, though, isn't a proffer enough?
In certain instances, yes, Your Honor.
Hold on. If it's only certain instances, tell me when it's not, right? I think typically the case law is a proffer is sufficient to preserve evidence you're trying to get in, that's excluded. So you said in certain instances, if you think I'm wrong, which instances is it sufficient and which instances is it not?
So
Or is it just always sufficient and you misspoke?
I'm struggling to think of an instance in when it isn't sufficient at the moment.
So you agree it's always sufficient? Or at least there's no instance you can think of in which that's not sufficient?
Correct, Your Honor.
When you proffer evidence that's sufficient to preserve any legal arguments to admit it?
Correct, Your Honor. And even if the proffer in this case did somehow preserve this
Hold on.
issue,
You just said it's always sufficient. Why are you now saying even if it was somehow sufficient?
I apologize, I misspoke, Your Honor.
You said it's always sufficient, right?
Correct, Your
And
Honor.
he did it here.
Yes, Your Honor.
So is it preserved?
No, Your
Why
Honor.
not?
Because, well, as far as the transcript goes, I'm not aware of any point in which he actually did proffer this additional mitigating evidence. I mean, the judge gave him multiple opportunities to speak again, contrary to what his argument is. And time again, I can point to multiple instances in the record where after he indicated that he wanted to keep speaking, the judge allowed him multiple opportunities to offer a final word. And so,
Counsel, does counsel below have any obligation to tell the judge why the proffered evidence is relevant?
yes, Your Honor, so that they, in efforts to preserve this issue, I believe. And, but all of that aside, because the appellant entered a guilty plea in this case, the range of issues that he could have reviewed on direct appeal are limited by Florida Rule of Appellate Procedure 9.140B2A2. And because an error in the sentencing process is not.
Can rules? I guess let's just get right to Emerson then, right? So to say that the rule 9.140 limits what he can appeal presumes that that defines what he can appeal, right? As opposed to implement some higher regime. And tell us why the dissent in Emerson is wrong then. The dissent in Emerson, the way I take it is essentially the Constitution gives you certain rights. The rule can only implement those rights. It can't eliminate them, right? And so even if the rule tried to, it couldn't eliminate the right to appeal this. And by the way, it doesn't try to because otherwise provided by law, the Constitution law. And what uses the phrase law is a broad term, right? Normally, when something is referring to specifically a statute, it might say by general law or something indicating statute. It just says law. I don't think there's any definition of law that doesn't include the Constitution. So I think the point of the dissent in Emerson, which seems really compelling to me, is the Constitution gives you a certain appellate rights. The Supreme Court has recognized that. Rules can't take them away even if they try. And this one doesn't try because it says as otherwise provided by law, and the Constitution is law. Why is the dissent in Emerson not right?
So in response to that, Your Honor, I would say that the Constitution does provide the right to appeal issues at trial. However, as the Florida Supreme Court stated in Leonard v. State, there have been limitations that have been placed on that right to appeal. And I believe Judge Tannenbaum also addresses that in his dissent as well.
Yeah, he says you can limit it to being preserved errors.
Correct, Your Honor.
Yeah, so assuming it was preserved, why can't you appeal it?
Because that the rule of Florida appellate procedure doesn't allow for such an appeal.
So counsel, you're not answering the question. The rule cannot change the Constitution, right? The Florida Supreme Court has said the Constitution gives you a right to appeal preserved errors. Okay? So the rule cannot change the Constitution, even if it wanted to, right? Even if that was Supreme Court's intent, which I think the dissent points out is unlikely. But then in addition to that, you have that otherwise provided by law language. So it would seem that that would encompass appeals granted by, permitted by the Constitution. So just saying 9.8 or just saying 9.140 doesn't allow this, doesn't answer the question. Why does the Constitution not allow it? What would give 9.140 the ability to override a constitutional right to appeal? And B, why does otherwise provided by law, I think it's subsection E, why does that not encompass this such that the rule isn't trying to change the Constitution or override the constitutional right?
And I think that's a very valid concern, Your Honor, and it's a great question. And unfortunately, I can't speak to that very well at the moment. I will say that
It's the key issue with the case.
correct, and that's why this issue has been certified as a question of great importance to the Florida Supreme Court so that they can hopefully provide some clarification on.
So the primary issue in the case upon which you gave us a notice of supplemental authority, you're not prepared to speak to the primary issue in the appeal and the most recent case on it that spoke to that issue that you provided to us right before the argument?
I wouldn't say that at all, Your Honor.
Counsel,
I'm not-
how would you interpret subsection E? As otherwise provided by law, what does that mean?
I would interpret that as examples where the court has provided an exception to this type of rule, whether that be through case law or statutory law.
So more than just statutory laws, otherwise provided by law would also encompass case law. Would it encompass, as Judge Mize has suggested, the Florida Constitution?
Yes, Your Honor, I would say so. And the only instance that I was able to find on subsection E in this case, or under this rule, were instances where the appellant was claiming double jeopardy. And I've never seen any other instance where an appellant who entered a guilty or no contest plea was able to appeal any other issue that isn't specifically listed under the rule. And just to, I'm sorry, go ahead.
Otherwise provided by law is listed under the rule, right?
Correct, Your Honor. However, I don't believe that that specifically allows for any type of appeal. And that's
Well, not any type of appeal, but the question is, does it allow for the appeal of a preserved sentencing process error?
I would have to say no, Your Honor,
Why?
because in this case, the appellant entered a guilty plea, and if we were to allow subsection E to encompass an error in the sentencing process in this case, then essentially subsection E renders the entire rule useless because
So why does it render the entire rule useless? It would allow for the appeal of something that occurred after the guilty plea that is preserved. It would still 9.80 or 9.140 would still foreclose appeal of anything that occurred before the plea, right? That seems like a big use to me. I don't think you could say the rule is useless because it would still allow appeals of an error that occurs after the plea.
I'm sorry, could you repeat that one more time?
So you said if the subsection E otherwise provided by law allowed appeals of a preserved sentencing process error, that would render 9.140, that section of it, useless. All right, that's what you said. And even if what I'm saying is I don't see how that can be correct, because even if it allowed the appeal of post-plea sentencing process errors that were preserved, it would still foreclose appeals of all issues prior to the plea. So because it would still have a huge, enormous effect, I don't see how you could say that interpretation would make the ruling useless.
Well, not looking at it just in the context of this case of a sentencing process error, but potentially any type of appeal that a defendant may want to seek review of after entering a plea. And so when I say that it could render the rule useless in a sense, I don't necessarily mean only in this context, but in any context in which a defendant enters a guilty or no contest plea.
So you're saying it could allow the appeal of other sentencing process errors?
Or whatever other issue may come up.
Why would allowing if the rule allows the appeal of sentencing process errors that occur post plea and are preserved, why does that open the door to the appeal of any possible legal errors, including pre-plea legal errors? Why is that a thing?
I would say because of the language as otherwise provided by law, it's essentially operates as potentially like a catch-all provision. And that essentially opens the door to whatever type of issue may arise after entering a plea. And I think the rule itself was implemented in efforts to alleviate the appellate courts from certain issues that can be resolved below. And as Judge Nardella mentioned earlier, in this case, while this isn't reviewable on direct appeal, there is nothing that prohibits the appellant from collaterally attacking the sentence through a 3850 motion. And there are several mechanisms that have been provided to defendants that have entered a plea of guilty to appeal errors that may occur after the entrance of their plea.
For otherwise provided by law to open the door like that, wouldn't those other, I guess, potential errors you're opening the door to have to be provided for by law?
I would say yes, Your Honor.
So if something's provided for by law, aren't you supposed to get it? Isn't that what the purpose of providing for it by law is?
Correct, Your Honor.
It seems a weird thing to say this would open the door to following the law. It seems like a weird argument.
Well, not necessarily
There's
that it,
laws that might give them right to appeal, and this would allow those laws to have effect. It seems odd.
right, and as important as the right to appeal is, again, there have been limitations placed on that. One of those limitations being the preservation requirement itself.
Counsel,
No, I'm sorry.
is there another limitation besides preservation, which I think would put in the realm of like a procedural limitation, how you implement a right? What other limitations can you cite?
In this case, Your Honor, well, I would say that it's the fact that there also is no fundamental error or exception to this type of issue in this case. And as you said earlier, Dortch v. State lays that out pretty clearly. And contrary to what opposing counsel said, although Dortch does specifically address a defendant who claims that they entered an involuntary plea, which is specifically listed under the rule, the court found that it wasn't reviewable under fundamental error, even because it wasn't preserved. And I find it difficult to follow that if the Supreme Court ruled that an exception or that an appeal that is reviewable after entering a guilty or no contest plea that is listed in the rule isn't subject to fundamental error, I don't see how it logically follows that they would find that an error that isn't listed under the rule is reviewable under fundamental error. Does that answer your question, Your Honor?
Well, fundamental error is tied to preservation, right? So if we were to find that subsection E only applied to errors that were preserved, wouldn't that change your analysis?
Not necessarily, because there have been instances that I've seen, such as double jeopardy, where you can have that reviewed on fundamental error regardless of whether or not.
Even when you're. No.
And even in the event that this court does find that this issue is reviewable because it was objected to and preserved, or whether this court finds that it's reviewable under fundamental error, it's the state's position that there was no error in this case because appellant was allowed to testify at length at his sentencing hearing prior to being sentenced.
How much could the court cut that off? Like, could the court say 10 minutes is enough or 20 minutes is enough? Like, is there some line of time that you would say, no, we didn't have enough time to speak his piece?
I have not found any authority that states that there is a specific allotted time. I will say that the judge notates that he had been testifying for about 30 minutes.
Yeah.
And
He's looking at 30 years, right? So that's like a minute per year.
correct. And in the transcript, you'll find the judge sort of sympathetic to the defendant because he states, I know this is a long time, and I feel it's important that when defendants are sentenced to a long time, that they have the opportunity to speak.
You know, if
However,
the judge had cut him off at 20 minutes, would that still be okay?
depending on the content of his testimony, potentially, because
How about 10?
again, I would say depending on the content of his testimony, because the issue here wasn't necessarily that he spoke for too long. It was that his testimony wasn't exactly relevant to his sentencing or to the mitigation of his sentencing. And as we discussed earlier, there was no substantial assistance agreement from the state presented here, nor was there a motion for downward departure.
Doesn't that go back to your concession earlier that you just have to put forth the evidence and that preserves all legal arguments to get in the evidence?
I'm not sure how that contradicts my point earlier, Your Honor. if you
My
could-
point is if all you have to do to preserve is proffer the evidence, then you don't have to give the specific legal basis that is relevant. And you conceded that earlier.
Well, I wouldn't say that proffering the evidence alone is enough to,
You said that earlier.
I apologize, Your Honor. I misunderstood the question. But unless there are any additional questions, I'll rely on the arguments in the brief and ask that this court affirm the trial court sentence in this case. Thank you.
Thank you, counsel. Mr. Cordell, whenever you're ready.
Hey, please the court. First, I want to refer to whether or not the issue was preserved. Florida Statute 9104 rulings on evidence subsection B. When the ruling is one excluding evidence, the substance of the evidence was made known to the court by offer of proof or was apparent from the context within the questions were asked. If the court has made a definitive ruling on the record admitting or excluding evidence either at or before trial, the party need not renew an objection or offer an offer of proof to preserve a claim of error for appeal. So I believe that we preserved our issue under the statute by presenting. I don't think we had to do a proffer. We did in an abundance of caution.
Counsel,
asked-
I think what we're struggling with is the trial judge told you, in essence, that he didn't think that the proffered evidence was relevant to A, and there was no legal argument made that it was relevant to B. Is it your position that the statute doesn't require you to make to correct the judge as to why the evidence is relevant as long as you proffered it?
That is my position. And then to follow up on the question of how did the judge keep you from saying that, he left the bench. He walked off and they were going to take my client back to jail. And I said, no, we're going to offer this, or we're going to proffer this testimony. My client testified. And at the end of it, I said, I wanted to include that. This is to an empty courtroom because I think it would have been relevant for the judge's consideration in sentencing. I made the argument and the judge just wasn't on the bench.
I think the ruling or the evidence that the language is most compelling of that is it says a court may predicate error and grant new trial, set aside aversive judgment for excluding evidence when the substance of the evidence was made known to the court. I think what you're saying is maybe it would be more fair to the trial judge if he or she was entitled to the legal argument, but the statute doesn't say you have to do that.
That would be my position. That's always how I've known to
Yeah.
preserve things is if there's any doubt, proffer it, you've preserved it. I was trying to do everything I could.
Because what you're saying is, well, you didn't do everything you could.
I was trying.
All right,
I didn't say relevant until he left the bench.
Correct. But you didn't say what it was relevant to.
Yes.
All right. So you didn't do everything you could in
Right.
fairness. But I think what your best argument is maybe it wasn't fair to the trial judge, but the statute says I don't have to be fair to the trial judge. There's no rule that statutes have to be fair to trial judges.
I agree with that. And I did say at my page 71 of the sentencing transcript after testimony, I said I wanted to include that because I think it would have been relevant for the judge's consideration in sentencing. I didn't say it was about specifically substantial assistance. I said it was relevant word sentencing. It's mitigation. I direct the court to the language in Ventura where the opportunity to address the court is important, even involving a mandatory minimum. Quote, respecting the right of the defendant to address the court maximizes perceived equity of the process, citing the ABA. I think it's really important that a defendant be allowed to fully address the court.
All right, counsel, you're out of time.
Understood. Thank you. Your
Before you
Honor.
leave, are there any other questions?
Thank you.
Court is adjourned.